Good morning, everyone. Welcome to Ask a Property Manager, episode 33. Today's August 12th, 2020. Coming to you live from Studio 2.0 here at Own Buffalo. I'm Andrew Schultz, principal broker of Own Buffalo, Inc. And on today's show, we're going to be looking at the eviction moratorium updates as well as answering some questions from landlords around the country. Before we jump into that, we're going to plug our social media. New episodes of Ask a Property Manager drop every Wednesday at 10 a.m. Eastern. You can catch those live on our Facebook page at facebook.com/Buffalo Foreclosed Homes. You can also catch the replays there on our Facebook page as well as over on our YouTube channel. We usually get those up the same day, so if you are following our YouTube channel, you're getting that the same day that we're posting it live on Facebook. Also, feel free to follow us over on Instagram. We post content over there that we don't typically post on our Facebook and YouTube pages, a little bit different content, so that's something that's definitely worth checking out. Last but not least, you can grab a free 30-minute phone consultation over at ownbuffalo.com. There's a link right on the homepage that you can click on to register for one of these free consultations. A free 30-minute phone call or Zoom call with me. I do have a couple of time slots available still for this week, and then we also have some time slots available for next week as well, while that loads up. It's a great opportunity for you to get in contact with me. It's not a sales session. I'm not looking to push a product on you or something like that. It's just a great way for me to help people who are uncomfortable asking a question in the comments, or maybe they have something that's a little bit more sensitive. They don't want to expose it publicly. It's a great opportunity for you to get in front of me, ask the questions that you have, get some answers and things like that. You can see that we have our second page loaded, so this is going to be next week's time slots. We do have quite a few slots open for next week. Definitely take advantage of that. Last but not least, don't forget about the Rent Prep for Landlords podcast. We publish the Rent Prep for Landlords podcast every Thursday morning. So that means there's a new episode dropping tomorrow if you're watching this live. Tomorrow we're going to be discussing insurance policies for landlords, as well as how to set the price of your rental and how to interact with your tenants on a social level. So don't miss out. New episodes drop every Thursday morning, everywhere podcasts are heard. You can also catch the podcast over at rentprep.com/podcast. I do want to drop a quick plug for a video that I did last week. This was posted last Friday. Breaking news, Governor Cuomo extends the eviction moratoriums in New York. What options do housing providers have? This is available. You can get your link on our Facebook page. It'll take you over to YouTube where you can watch the actual video. This is a great little segment. It is 6 minutes, 31 seconds long. You can probably skip the last minute because it's mostly just me plugging social media at that point. But this will give the landlords here in New York the opportunity to see what's going on in the world and kind of get a feel for what the current eviction moratorium is here in the state of New York. And then subsequent to this video, which leads us right into our first topic of the day, was an executive order that was signed by President Trump that extends the eviction moratorium as well as I believe the foreclosure moratorium. But I wanted to scroll down through here and actually read through part of this because people keep asking, what does this mean? What does this mean? What does this mean? So currently the federal the federal eviction moratorium runs to, I believe, August 31st. And then this extends it in theory. So I want to read through this a little bit here. The CARES Act imposed a temporary moratorium on evictions of certain renters subject to certain conditions. That moratorium has now expired. Okay, so I was wrong on my date. And there's a significant risk that this will set off an abnormally large wave of evictions. With the failure of the Congress to act, my administration must do all that it can to help vulnerable populations stay in their homes in the midst of this pandemic. Those who are dislocated from their homes may be unable to find shelter in place and may have more difficulty maintaining a routine of social distancing. They will have to find alternate living arrangements, which may include a homeless shelter or a crowded family home and may also require travel to other states. In addition, evictions tend to disproportionately affect minorities, particularly African Americans, Latinos. Unlike the Congress, I cannot sit idly by and refuse to assist vulnerable Americans in need. Under my administration, minorities achieve the lowest unemployment rates on record. We will not let COVID-19 erase these gains by causing short-term dislocations that could have long-term consequences. Accordingly, my administration, to the extent reasonably necessary, to prevent the further spread of COVID-19, will take all lawful measures to prevent residential evictions and foreclosures resulting from financial hardships caused by COVID-19. That was basically a stump speech, for what it's worth. Now we're going to actually get into the meat of the matter, if you will, and talk about what exactly is being proposed here. Section 2, policy. It's the policy of the United States to minimize to the greatest extent possible residential evictions and foreclosures during the ongoing COVID-19 national emergency. Sounds good. Section 3, response to public health risks, evictions, foreclosures. The Secretary of Health and Human Services and the Director of CDC shall consider whether any measures temporarily halting residential evictions of any tenants for failure to pay rent are reasonably necessary to prevent the further spread of COVID-19 from one state or possession into any other state or possession. That doesn't do anything. All this says is that they shall consider whether any measures temporary halting evictions are reasonably necessary. So shall consider. There's nothing actually being put in place there. Secretary of Treasury, Secretary of Housing and Urban Development shall identify any and all available federal funds to provide temporary financial assistance to renters and homeowners who, as a result of financial hardships caused by COVID-19, are struggling to meet, are struggling to meet their monthly rental or mortgage obligations. Secretary of Housing and Urban Development shall take action as appropriate and consistent with applicable law to promote the ability of renters and homeowners to avoid eviction or foreclosure resulting from financial hardships caused by COVID-19. Such action may include encouraging providing assistance to public housing authorities, affordable housing owners, landlords, and recipients of federal grant funds in minimizing evictions and foreclosures. Again, nothing's really being done here. This is all just puffing chest, pomp, and circumstance. In consultation with the Secretary of the Treasury, the Director of FHFA shall review all existing authorities and resources that may be used to prevent evictions and foreclosures for renters and homeowners resulting from hardships caused by COVID-19. Sorry, I almost knocked over my coffee mug there. And that pretty much, the rest of this is just general provisions and whatnot. And this was the White House, signed by Donald Trump at the White House, August 8th. That was on Saturday. So this doesn't really do anything. In its current form. It started effectively as basically a stump speech talking about what they want to do, and then providing some general direction to the Secretaries of Health and Human Services and the Director of CDC. There's nothing concrete here is the point that I'm trying to convey. So While Trump did issue an executive order, and while in theory that executive order is supposed to extend the eviction moratoriums, there's nothing of substance in here. So that's something to keep in mind as you're reviewing this sort of thing. How the federal eviction moratorium will play into the individual state eviction moratoriums remains to be seen. Here in the state of New York, we are under an eviction moratorium until September 5th. There are some limitations. There are some opportunities there for landlords who are in some particular sets of circumstances. I definitely encourage you, head on over to YouTube, search for Own Buffalo, watch that video that I published last Friday on the 7th. Again, that was prior to this executive order from President Trump on the 8th. All of that being said, the executive order on the 8th doesn't really do a whole lot at the present time. So we're going to jump on into our questions and answers. So the first, actually, I wanted to start with this. This is something that I posted in the Rent Prep for Landlords Facebook group a couple days ago. Something I'm seeing more and more of, and this was targeted more towards the Rent Prep group, but just in general, I'm going to make this statement. Keep in mind that anything you post online should be considered publicly accessible. It doesn't matter if it's on a friend's wall. It doesn't matter if it's on your wall. It doesn't matter if it's in a group that you think is closed or private or secret or whatever they call it on Facebook nowadays. Anything that you post on the internet should be considered available for public consumption. And there are a lot of people who I'm seeing posting things that, number one, I don't think they would post in different times. But it's one of those things where if you're posting something online, you need to consider the fact that someone may disagree with it. Someone may choose to, disagree with you and find your contact information, or try to cause harm to you in some capacity, whether online or, whatever the case may be. Be smart about what you're saying online. Be smart about what you're doing online. Be smart about what you're liking and commenting on and things like that. Be safe when you're online. Just, it is what it is. I think this is more or less coming from a position of, last week we covered that there was a landlord that was murdered by one of his tenants, and it sounds like it was a house sharing situation, a house hack situation. But that's not the first time that we've heard about this. It's not the first time we've heard about it in 2020. Honestly, it wasn't even the first time that I'd heard about it in July and in August. It's becoming more and more frequent. And as a housing provider, unfortunately, to some people, you have a target painted on your back. So being safe online and being safe in how you conduct yourself and how you conduct your business is critical. I'm going to get off my soapbox. I think that's all I really needed to say about that. But just be mindful of the things that you're saying online. So let's talk about correcting a lease. When correcting mistakes on a lease, for instance, correcting the wrong apartment number, would scratching it off without having tenant's initial next to the correction be binding? I'd always assumed that any corrections done where something is crossed out with a pen on a lease had to have tenant's initials to prove that they agree with the new changes to the agreement. Yeah, that's correct. If you're going to correct something on a lease, cross it out, and anybody who signed the lease should be initialing that change. So if you had, two tenants and they both signed the lease, both of them should be initialing that change. The landlord should initial every change as well, just so that everybody is on the same page. You may even want to throw a date next to your initials if that, tickles your fancy. Very straightforward. Cross it out. Everybody puts their initials next to it so everybody's in agreement. And then if you need to, make sure that you circulate fresh copies to everybody so everybody has the most up-to-date copy. If you could just make changes to a lease without having everyone's initials on it, there's nothing that would stop a landlord or a tenant from making just changes to the lease unilaterally, not notifying the other person that they had made changes to the lease, and then trying to act as though that is the valid and enforceable agreement. So yeah, if you're correcting a lease, you definitely need to make sure that you are getting that correction initialed or signed off on, or whatever the case may be. In this particular instance, you mentioned that it was a wrong apartment number on a lease. In that instance, I would probably actually request a fresh copy of the front page of the lease, simply because down the road you don't want there to be some kind of an issue where they try to use that document for verification of address or something, and because it's got pen marks on it, some agency or regulatory authority or something just won't take it. That's a real simple one to just bust out a fresh page one with the correct apartment number on it, correct unit number on it, and move forward. Our next topic is small claims court. I will be sending a security deposit claim letter to a tenant who just moved out. She will not be getting any of her deposit back due to damage/cleaning charges. In addition, there was damage over and above the amount of the security deposit, several $100s. I plan to give a deadline to pay, after which I will file in small claims court. How long is long enough? 2 weeks, 30 days? I don't see anything in my state, New York regulations. I'll preface this by saying I'm not an attorney. I don't know if there's any kind of a restriction as to how long you have to give someone in a demand letter before you take them to small claims court. Generally speaking, we'll say 30 days. We'll put a note on there, that we want to try to resolve the issue or work out a payment arrangement or whatever the case may be. And we'll give them usually 30 days to make that arrangement, to reach out to us and make some kind of an arrangement. You may want to send, when you send your demand letter, you may want to send along a copy of the evidence that you have showing the damages or showing that things were not left clean. Before and after photo sets are so important for this very reason. Generally speaking, if you have a good itemized list and you say, this is what we charged against your deposit and why, and you can back that up with photographic evidence or something along those lines, it's going to make your case a lot easier if you do wind up in small claims court. But honestly, what we've found is that when presented with the evidence, most people will start to come around and say, all right, we're going to have to work something out because I don't want this to go to small claims court or whatever. So by including what you have up front, look, they're going to see it in court anyway. There's no reason to hide it. Just compile it and send it and say, look, this is what we have to go on. If you really feel that you are not responsible for these damages or whatever, we can take it to court. But this is, lay your case out. This is the case that we have. What is your case? And take it from there. And I think that you'll find that when you do present people with the evidence that you have, a lot more often than not, you're going to find that they're not going to be happy about it in a lot of instances, but generally speaking, they're going to be more willing to work with you because they're not going to want to go through the court system and wind up with a judgment against them and everything else. Coming up next, city code violations. My house is in New Jersey and I live in Florida. I have a lawn service that comes to my property to mow the lawn every 2 weeks. However, my tenant sent me the notice from the city saying that I left a weed and it grew over 10 inches. I also saw the photo from the city. The weed did overgrow. The lawn service missed one part and mowed the rest. I don't know why they did that. What should I do? Should I talk to the city or the lawn service? I do have a property manager. Whose fault is that? So I guess the real question here is who's responsible for the lawn service? If it's something that's arranged by the property management company, I would go to the property manager and say, hey, just so you know, I received a citation because the lawn wasn't cut, or a portion of the lawn wasn't cut. The city issued a citation, whatever the case may be. Your property manager, if they're worth their weight in salt, and if they're the ones who are coordinating this vendor, should be able to contact that vendor, say, hey, you missed this spot. We need you to go back and take care of it so that we can get rid of this city violation. And then more often than not, as long as it's corrected, the city will probably waive if it's just a notice of correct, if it's before you get to a violation, more often than not, the city will just say, okay, it's taken care of. We're not going to pursue this any further. If you were the one who was orchestrating the lawn service, then I would contact the lawn service directly because it doesn't sound like your property manager has anything to do with the lawn service if you're the ones who are coordinating them. And I would just tell them, hey, look, here's the situation. I got a citation, blah, 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 and ask them to go by and take care of the problem. And then once the problem's taken care of, I would go to the city and say, all right, this is all set. Or have your property manager go to the city and say, all right, this is all set. If there's a fine attached to it, one thing you didn't say is if there's a fine attached to it. In terms of who's responsible for the fine, I would say that needs to be more information provided here. It sounds like the lawn service may not have known that they were supposed to cut a certain section or something like that. Depending on whose responsibility it was to set up the lawn service, it is what it is. Honestly, for something like this, it's probably one of those things where I would just pay it and move on with life. You're going to spend more time screwing around with it than you are actually just taking care of the situation and moving on. 2 properties, 1 contract. If you have verbally accepted offers on 2 multi-unit residential properties with the same seller, would you try to wrap them into 1 contract, or does it make more sense to do a separate contract per property? I'm located in Pennsylvania and don't know if the law says anything about this or if 1 contract for both would even benefit me. I would actually go 2 properties, 2 contracts. And I'll use an example that we had here in Buffalo. So we had a property, it was actually 2 4-unit buildings that sat right next door to each other. And between the 2 buildings, there was a common driveway that led back to a common parking area. Basically, half the driveway and parking was on one property, and half the driveway and parking was on the other side of the driveway, or the other side. Yeah, so each side basically had half of the driveway and half of the parking area. So, buying one of those properties without buying the other one of those properties would suck. Could you do it? Yeah. Would you want to do it? No, because you're going to be dealing with your neighbor with a shared driveway and parking lot situation. It's not a good spot to be in. So the properties were sold together. The properties had 2 separate tax IDs. So what we did was put each property on its own separate tax or on its own separate contract. And the nice thing behind that is if one property was able to close, but the other was held up for a title issue or something like that, you could make a decision at that point, okay, do I want to move forward on one of these transactions while the other one gets ironed out? Do I want to wait until both transactions are ready to close simultaneously? You've got a little bit more of an aspect of control there. So that is something to definitely consider. If you're going to do 2 properties, 2 parcels, 2 buildings, I would probably do it as as 2 separate contracts. Something else to consider, a lot of times you'll find, especially here in the city of Buffalo where we have narrower lots, you'll find that you might buy a residential property and it comes with the narrow lot next door that used to be a house that had burned down and the homeowner had purchased the vacant lot essentially. That is a transaction that you may want to consider doing separately because vacant land is taxed differently than residential single or multifamily in the city of Buffalo. So you're going to pay a lesser tax rate on that vacant plot than you would on the property that has the home on it. And if you combine those 2, you're paying the higher tax on the entire thing. So that's definitely something to keep in mind when you're talking about properties and tax IDs and contracts and things like that. So that pretty much wraps things up for today, guys. Thank you so much for joining us. I love producing Ask a Property Manager, and you guys can always help us to improve by dropping a question in the comments, either on Facebook or on YouTube, and your question may be answered in an upcoming episode. If you enjoyed this content or if I brought some value to your day, please do me a favor and hit that thumbs up button. YouTube and Facebook both push videos based on community feedback, so every like, comment, subscription, and share helps us to grow and reach more people. Next week's episode will air on Wednesday, August 19th at 10 a.m. We're going to be back with another episode you won't want to miss. Thank you all so much for watching, and we'll see you next week.